There is a privilege called the Members-Only Wellness Exemption. It appears in no law you've read, and it leaves no public record because Congress wrote the rule that lets it hide. Here's what it actually is. Inside the Rayburn House Office Building, there is a private gym, pool, sauna, basketball court, personal trainers, taxpayer subsidized. Members of Congress use it for a fraction of what a commercial membership costs blocks away. Staff can't get in. The public can't get in. And under House Ethics Manual guidance, none of it counts as a gift, not the subsidy, not the access, because it's classified as an official member's service, a category the House invented for itself, administered by the Committee on House Administration, and never once submitted to the ethics disclosure process that governs everything else a member of Congress receives. Here's how that happened without anyone voting on it. In 1995, Congress passed the Congressional Accountability Act, a law that finally applied basic workplace protections, like OSHA and anti-discrimination rules, to its own employees. It was sold as an accountability measure, Congress holding itself to the same standard as everyone else. But buried in the implementation was a carve-out. Internal facilities and services for members would be governed not by statute, but by resolutions of the House Administration Committee, internal orders that don't go through committee markup, don't get published in the Federal Register, and aren't subject to the Freedom of Information Act, because Congress exempted itself from FOIA decades earlier. No hearing created the gym exemption. No floor vote ratified it. A committee simply decided members' fitness perks weren't gifts in the legal sense, and that decision has never been revisited. Now here's who actually controls it. Not the full House. Not the Ethics Committee, which handles gifts from outsiders, lobbyists, donors, corporations. This sits entirely with House Administration, a committee most Americans couldn't name, that also controls parking assignments, office furniture budgets, and cafeteria contracts. It functions as an internal facilities board with the authority to decide unilaterally what counts as compensation and what counts as workplace upkeep. That distinction matters more than it sounds. A member who accepted a comparable subsidized gym membership from a private company would have to disclose it, possibly return it, possibly face an ethics complaint. The same benefit, funded partly by public money and administered 100 feet from the House floor, requires no disclosure at all. And here's the concrete power that gives them. Every year, members file a financial disclosure report, the document reporters and watchdog groups use to track outside income, gifts, and potential conflicts of interest. The gym doesn't appear on it. Not the value of the subsidy, not the frequency of use, not who they talk to inside it. And people do talk inside it. Congressional gyms have a long, quietly acknowledged history as informal deal-making space, bipartisan basketball games, sauna conversations, negotiations that never touch a public hearing room. In 2011, during debt ceiling negotiations, multiple accounts placed key informal conversations happening inside that same building's recreational space, outside any recorded session, outside any transcript, outside any FOIA request that could ever surface them. The public record of American governance has a hole in it shaped exactly like a locker room. And remember, no one voted on that hole existing. Here's the part that should actually worry you: it's completely legal. Every piece of this survives because it was built to survive scrutiny, not to avoid it. The exemption isn't hidden through concealment. It's hidden through categorization. It was never called a gift, so gift disclosure law never applies. It was never called legislation, so no repeal process exists. You cannot repeal an internal committee resolution the way you repeal a statute. There's no bill number, no sunset clause. No court has standing to review it because no one outside Congress is harmed in a way the law recognizes. The only body that could undo it is the same committee that created it, made up of the same members who benefit from it. That is not a loophole. That is a structural lock, engineered so the people with the power to change the rule are the only people with no incentive to. What this tells you is uncomfortable. If a wellness perk can be quietly reclassified out of the disclosure system, So can anything else that a facilities committee decides to define as internal administration rather than compensation? The gym isn't unusual. It's a demonstration, proof that the line between what Congress must disclose and what it doesn't isn't drawn by ethics law. It's drawn by which committee gets to name the thing first. So the real question isn't about a gym. It's about how many other quiet definitions like this one are sitting inside committees you've never heard of, waiting to be noticed.